Okay, guys, you might be wondering why I've been doing live videos all the time this week. And the reason is I'm busy and it takes a lot longer to edit a video than just to do a live video. And this is kind of breaking news. It broke actually like an hour ago, but I was busy.
So you're within the 3-week rule for breaking news, is what you're saying.
Yeah, I try to break it as soon as possible, but we do have a decision, and this is a case from the Firearms Policy Coalition and Second Amendment Foundation and Minnesota Gun Owners Caucus, and it is Worth versus Jacobson, and it deals with the ability of people between the ages of 18 to 20 to get a permit to carry in Minnesota. There was a amicus brief filed on behalf of the NRA as well in this. Originally, a district court judge ruled that the state cannot ban people 18 to 20 from getting a concealed carry or permit to carry permit, and the state of Minnesota appealed it to the 8th Circuit. A 3-judge panel on the 8th Circuit has now ruled on that, and they affirmed the. Let me just go ahead and I'll mute my phone, my watch, and they affirmed the district court's decision. So what we're going to do is just going to go through it and
wait. It affirmed, which means 18 to 21-year-olds can't buy firearms?
No. 18 to 20-year-olds can get a permit to carry. This is a win.
Okay, win.
Yes, it's a win. So we're gonna go over it. The 3 judges on the case was Smith, who is the chief judge, Benton, and Strauss. And so we're just going to go over this stuff and then get out of here. I got to go finish up some other stuff. So, yeah, there is that. So let's go ahead and read the Worth opinion.
Dun, 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 dun.
And Dark will not be joining us today.
Okay, so this is Minnesota's permit to carry statute. Among its objective criteria requires applicants to be at least 21 years old. 3 gun rights organizations, Second Amendment Foundation, Firearms Policy Coalition, and Minnesota Gun Owners Caucus. I don't know those guys. Through their members, Kristen Worth, Austin Dye, Alex Anderson, and Joe Knudsen, challenge this age restriction for violating the Second and 14th Amendments of the United States Constitution. The district court granted summary judgment to the plaintiffs, finding the Second Amendment's plain text covered their conduct, and the government did not meet the burden to demonstrate that restricting 18 to 20-year-olds' right to bear handguns in public was consistent with the nation's historical tradition of firearms regulation. Minnesota appeals, having jurisdiction under 28 U.S.C. 129(1), whatever, this court affirmed. So boom, done.
Okay, so the Second Amendment, everyone knows what the Second Amendment is, so I'm not going to go over that. But the 14th Amendment, what the 14th Amendment did is say that the Bill of Rights and stuff like that applies to the states as well. Before 1868, there's some argument whether it only restricted the federal government or does it restrict state governments. The 14th Amendment said yes, the Bill of Rights does restrict state governments, so the states cannot violate their citizens' rights. So
The
that is what that is. So just explaining that. All right, go ahead.
the Minnesota Citizens Personal Protection Act of 2003 criminalized carrying handguns by ordinary people, not peace officers, in a public place unless they have a permit to carry. To get a permit to carry, among other objective criteria, an applicant must be at least 21 years old. State law since 2003 therefore bans those under 21 years of age from carrying handguns in public, the carry ban. The individual plaintiffs wished to carry handguns in public, the district court found, except for failing to meet the age requirement. They were otherwise eligible to receive a permit to carry a pistol in Minnesota. Worth v. Harrington. The
So
organizational plaintiffs collectively have thousands of members in Minnesota. The
basically,
plaintiffs
basically what they were saying is they weren't disqualified for any other reasons besides age. So it's going to lead the state government to prove that their law is consistent with the nation's text, tradition, and history of gun regulations, which they cannot do, as you will see.
The plaintiff sued the commissioner of the Minnesota Department of Public Safety, the permitting scheme's state administrator, and the sheriffs of Mille Lacs County, Douglas County, Washington County, local adjudicators of permit applications in their official capacities. The plaintiffs allege Minnesota's state statute is unconstitutional, facially as applied to the individual plaintiffs.
Yeah, shout out to Ting Ting. I haven't seen Ting Ting around too much, but she is out there. Okay, so this is what the plaintiffs asked for.
Declare Minnesota statute blah and blah blah and their derivative regulations and all related laws, policies, practices, and customs violate facially as applied otherwise qualified 18 to 20-year-olds or as applied to otherwise qualified 18 to 20-year-old women, the right of plaintiffs and plaintiffs similarly situated members to keep and bear arms as guaranteed by the Second Amendment and 14th Amendments to the United States Constitution, and enjoin defendants, their officers, agents, servants, employees, and all persons in active concert participation with him from enforcing against the plaintiff and plaintiff's similarly situated members Minnesota statutes, blah, and their derivative regulations, and all laws, policies, practices, and customs that would impede or criminalize plaintiffs or plaintiffs similarly situated members' exercise of their right to keep and bear arms. Booyah!
Now they're going to go over the two-part test. The two-part test, as established under Bruin, is first the original text of the Second Amendment, the plain text of the Second Amendment. Now, after it passes that, once it says, the right to bear arms shall not be infringed, and they look at that and go, yep, this is infringing, and then it moves on to the second step, which puts the onus on the government to prove that their regulation is consistent with the text, tradition, and history of the Second Amendment from the founding era, 1791, even though that certain states are trying to argue that the founding era is actually 1868, the ratification date of the 14th Amendment, which puts it during the Reconstruction period where a bunch of Jim Crow laws were enacted.
The district court, you want me to read this or?
Yeah.
The district court applied the two-part
Actually,
test.
you have to read that. That's basically
Yeah,
what I
you
just said.
summarize that.
All right.
This
Go ahead.
This court reviews de novo a grant of summary judgment, Torson v. City of Rochester, as his as this is a factual challenge to the individual circumstances are not important, as the carry ban must be unconstitutional in all applications to 18 to 20-year-olds, United States v. Vesely, quoting Bucklaw
Now
versus,
you don't have to redo all that. That's just
wow.
jibber jabber.
In effect, the plaintiffs are asking for this court to affirm the grant of factual challenge, are speaking for a range of people, all
Patient.
those 18 to 20-year-olds,
Okay, go ahead.
who want to publicly carry a firearm for self-defense. A factual challenge requires the challenger to establish that no set of circumstances exist under which the act would be valid. United States versus Rahimi, quoting United States versus Salerno. Why can't I talk today? Salerno, the court,
You
to
you don't
counter
have to
a
read it.
factual challenge, the government must do its is identify constitutional applications using the same text and historical understanding framework, United States v. Vesely. All the individual plaintiffs now over 21 years old may now apply for a permit to carry. Their claims by and through whom the organizational plaintiffs had standing are moot, Hoss versus Page. To avoid mootness of the entire case before the last individual plaintiff turned 21, the plaintiffs moved to supplement the record with affidavit of Joe Knudsen, a 19-year-old Minnesotan seeking permit to carry, who is a member of all three organizations, in order to continue standing of the organizational plaintiffs.
Okay, let
The
me explain
organization,
that. Let me
sure,
explain that.
good
Basically,
point.
this started, all the plaintiffs were under 21. It takes a long time stuff to work through the court system. So they aged out. So basically, they're 21 now. So if they didn't add another person to the case would be moot because there's no actual damages anymore. But by them adding Knudsen to this, he's 19. You see this a lot. So this actually gives them, it continues their standing where they would not have standing if they didn't.
Right, because they aged out.
Correct.
The organizational plaintiffs assert standing solely as the representative of its members, Rath v. Selden. To have standing, an organization must demonstrate that its members would otherwise have standing to sue on their own right. The interests it seeks to protect are germane to the organizational's purpose. Neither the claim asserted nor the relief requested requires the participation of an individual members in the lawsuit. Students for
Basically, since Knudsen and they have other people under 21 that's members, they can sue. So
and yeah, the rest of it isn't pertinent. As for A, since the filing of the complaint, the organizational plaintiffs have demonstrated that at least one of their members has had continuous standing. The Friends of Earth v. Laidlaw, whatever services, the
it's basically
description.
saying they still have standing because
Yeah.
they're members. Then
So
it goes into, I'm just going to skip through
okay.
all this. Then it goes through saying, the purpose of the organizations is to protect gun rights. So there you go. And to go down here, start now.
So Minnesota does not contend that the organizational plaintiffs failed to meet the organizational standing test. Instead, Minnesota asserts that the court should not supplement the record because the below has no evidence about Knudsen. Wow, that's so Dakota Indus Inc. versus Dakota Sportswear Inc.
You don't have to read
Generally,
go ahead.
Generally, an appellate court can consider evidence that was not contained in the record below. However, this rule is not etched in stone. When the interests of justice demand it, an appellate court may order the record of case enlarged, citation submitted, Carpenters Pension Fund versus Illinois,
You don't have to read
of
the legal.
Illinois versus Needhoff. Okay. Maintaining that general principle of not supplementing the record on appeal is most applicable when the supplemental evidence does not impact the outcome of the present case, Torrey versus City of St.
You
Louis.
don't have to read the legalese.
Okay.
Okay, what this is basically saying is the state tried to argue that they couldn't add Knudsen to the lawsuit because he wasn't in it when it went to the district court.
Wow.
But the judges said yes, we can add his declaration and everything because it will impact the outcome of the present case.
That's a bit of a smackdown.
Correct. Go ahead.
In a facial challenge, individual circumstances are irrelevant from establishing standing. Let's see. In a facial constitutional challenge, individual application facts do not matter. Once standing is established, the plaintiff's personal situation becomes irrelevant. Specific to mootness, courts may consider any evidence bearing on the appeal has become moot. And scroll down. Blah. In Parents Involved in Community Schools versus Seattle District Number 1, after organizational members with standing aged out, the Supreme Court accepted affidavit from organizational listings of other members with standing, see blah. The court grants the motion to supplement the record and denies the related motion to dismiss the appeal. The organizational plaintiffs have an unbroken chain of standing through Cutson.
Okay. Hey, stop right there. Too many choices. I corrected them like 8,000 times in every video we've ever done. He's not going to change. It's a facial challenge.
Because I say facial, you don't like that?
That's not the way you say it. But that's neither here nor there.
Let's skip the reading of the Second Amendment.
Yeah. But what the state is trying to do is they were trying to get it thrown out on mootness because they knew that was their only chance of winning this.
The Supreme Court has applied
this is like just saying that the 14th Amendment applies here, and it highlights McDonald versus City of Chicago, the late great McDonald won that case. It's one of the biggest cases. So if you haven't read Heller, McDonald, Bruin, those are the cases where you really have to reach. So it just goes into all the here. So let's just go down to the second part.
The test has two parts, text, then history. Focused on application of the normal and ordinary meaning of the Second Amendment language covers an individual's conduct, then the government must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. First, this court conducts the textual analysis, determining if the amendment's plain text covers the plaintiffs. Are they of the people with the right to keep and bear arms? If so, then the conduct is presumptively protected.
Yeah, what we're seeing here is a lot of states are trying to claim the people are 21 and over, which is not really backed up by history, but that's what they're trying to claim because it's a losing battle if they can't prove that. So you are seeing the anti-gun states and anti-gun government agencies trying to argue all the time that the people the people aren't 18 to 20, even though the 18 to 20-year-olds have the right to vote. They're 21. If that was the case, then people 21 you would have to be 21 to vote, which is not the case. And I don't think Democrats want to see that. Go ahead.
Second, the burden shifts to the government to demonstrate that the regulation is consistent with the national historical tradition of firearms regulation. When the government regulates arms bearing conduct as when the government regulates other constitutional rights. It bears the burden to justify the regulation. Rahimi, quoting Bruin, the quote, the court analyzes the government's identified historical analogs, whether the government identifies a well established and representative historical analog, not to a historical twin,
Yeah.
Bruin.
Basically, if Rahimi said it doesn't have to be a historical twin, it could be something similar. It doesn't have to be word for word exact.
If the regulation is consistent with the nation's historical tradition of firearms regulation, it does not infringe on the right of the people. If not, then the regulation improperly infringes on the individual right to keep and bear arms. Boom. Bruin does not command us to consider only conduct in isolation and simply assume that a regulated person is part of the people. United States versus Citadel.
You don't have to read the legalese.
Okay. We must begin by asking whether the carry ban governs the conduct that falls within the plain text of the amendment. Citing Bruin, that is, Bruin tells us to begin with the threshold question using the plain text: are the plaintiffs part of the people?
Okay,
After,
I do want to touch on range here.
okay,
Range is a case where a guy was convicted of a felony for falsifying income on a application
oh yeah,
for food stamps.
and then he
They
was
will,
banned
yeah,
from.
yeah. So they basically made him a prohibited person for life. That case is it was GVR'd. Granted, yes, range got GVR'd, yeah. Granted, vacated, and remanded down to the courts. That's probably gonna go back to the Supreme Court, but the circuit court's gonna have to look at that again, and that's because
Wow.
by the time it got up to the court system, the whole Rahimi thing happened, and Rahimi said that person can be disarmed temporarily if they are a danger to themselves or others, which Range has no violent crime, and he's not a danger to himself or others. So that should be a victory.
Okay, this is crazy. Minnesota asserts that ordinary law abiding adult citizens that are 18 to 20-year-olds are not members of the people, and thus plaintiffs are not protected under the plain text of the Second Amendment. See Bruin.
Yeah.
It is undisputably that the ordinary law abiding adult citizens are part of the people whom the Second Amendment protects.
Yeah. Basically, we can skip all this.
Yeah.
Basically, like I said, states are trying to start arguing that the people are 21 and older, not 18 to 20, or not part of the.
Which is kind of crazy because I'm sure there's a vast body of law and regulation in Minnesota saying that they are adults and treating them as adults.
Correct. What they're trying to do is they're trying to move the goalpost a little bit. They're trying to shoehorn laws in by saying, "Oh, that's yeah, they're not part of the people." What do you? When they've never been part of the people. What are you guys talking about? You guys are crazy.
Wow. Okay. I mean, this is just like when the ATF argues a suppressor is a firearm and then argues in another case that a suppressor is not a firearm.
Correct. Good example there. All right, keep on going.
Keep on going. Minnesota argues 18, 20-year-olds.
We already covered that pretty much.
Yep.
And it's just going to go through all the laws that says here that says, 1821s are included part of the people, and it references a bunch of cases, which there's tons of. So just go down to here to Minnesota asserts.
Minnesota asserts that because 18 to 20-year-olds do not possess all their civil and political rights as minors at the founding, they cannot today be considered members of the people. Wow. Minnesota emphasized that political community at the time of the founding was restricted not only to those over the age of 21, but also to eligible voters namely white male yeoman farmers. It concludes that because those 18 to 20-year-olds were not legally autonomous members of the political community at the founding, they are not part of the people in the plain text of the Second Amendment. Woo.
So you
Arguments
have to
of
be
this
an
type.
they have to be so basically they're going with, oh, only white people automatically have their right.
So I'm not even going to go there. All right. Arguments of this type focusing on the original contents of the right instead of the original definition, the only that only those people considered in the political community in 1791 are protected by the Second Amendment instead of those, where are we going? Meeting the original definition of being within the political community are bordering on the frivolous. Yes. We do not interpret constitutional rights this way. Examining the interpretation of the First and Fourth Amendments, which consider modern forms of communication and search respectively, Heller rejected the idea that the Second Amendment protected only the contents of the defined term arms and instead applied to the original definition to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding.
Okay, basically what that is saying is like, well, if the Second Amendment only applies to muskets, then
Then
the
your
First
free
Amendment,
speech doesn't apply to TV, radio, or the internet,
TV, radio, or internet, it only applies to the quill.
right?
And if
And
you write
block
it
type
with
presses,
yeah, if you write with a ballpoint pen, that's not protected.
right? Whatever the likelihood that handguns were considered dangerous and unusual during the colonial period, they are indisputably in common use for self defense today, although its meaning is fixed according to the understandings of those who ratify the Constitution, can and must apply to circumstances beyond those the founders specifically anticipated.
Basically, the founders cannot anticipate the internet because it would be like magic or TV or
Well,
radio.
that's why they said keep and bear arms and not flintlocks or muskets.
Correct.
Similarly, Heller defines the people as all the members of the political community, not an unspecified subset. The Second Amendment extends prima facie to all members of the political community, even those that were not included at the time of the founding. Contrary to Minnesota's assertion, political community is not confined to those with political rights, eligible voters. At the founding, let's
Which I
see,
think is crazy because basically they're arguing that the only people are white people.
yeah, look, New York did the same thing after Bruin.
Yeah.
Even if Minnesota were correct in its assertions about the political community's definition, the contents of that defined term have changed. Since the founding, the guarantee of political rights has continually expanded, specifically in the right to vote, prescribing the abridgment of voting rights based on race, prescribing the abridgment of voting. I'm assuming they're going to go for women.
Yeah, just go to reading of the Second Amendment.
Yeah. Reading the Second Amendment in the context of the 26th Amendment unambiguously places 18 to 20-year-olds within the national political community, explaining that constitutional
Okay,
exegesis.
I want you to stop there for a second.
Okay.
Do you know what the 26th Amendment is?
Wait, the 26th Amendment, that's
What can you do at 18, Rich?
drink,
No. Vote. It's just a voting.
vote. Oh, okay.
So if we're going to go that, the people or the political community, then it would be based on age of vote. And I think you have to be 21 to drink.
So, Section 1, the right of citizens of the United States who are 18 years of age or older to vote shall not be denied, abridged by the United States or by any state on account of age. Section 2, Congress shall not have the power to enforce
You don't have to read
this.
this. You don't have to read it. All right, just go here.
Minnesota asserts that this court has held the people can have different meanings in different parts of the Constitution. Ouch. In Sittledine, this court held that the United States v. Flores is still good law post Bruin, reaffirming the holding that Flores that illegal aliens are not part of the people, citing United States v. Portillo Muniz. That holding is consistent with Heller. At a minimum, all Americans in the political community that are law-abiding citizens are members of the people. Let's see. Interpreting Heller's mandate.
Yeah, we can skip down here.
Third, it is not disputed that the plaintiffs are ordinary, law-abiding, or citizens. Only whether they are adult citizens, the age of majority or minority, is a status that lacks content without reference to the right at issue, rather than a fixed vested right. Let's see. Quoting charge. Minnesota seems to assert the age of majority is fixed at 21 permanently. Adult means individual 18 years of age or older. So that's Minnesota law. So this is not so for political rights. The 26th Amendment sets that age of majority at 18, which we just read. Fourth, Minnesota states that from founding, states have had the power to regulate guns in the hands of irresponsible or dangerous groups such as 18 to 20-year-olds. At the step one, the plain text analysis, a claim that a group is irresponsible or dangerous does not remove them from the definition of the people. Neither felons nor mentally ill are categorically excluded from the national community. That does not mean that the government cannot prevent them from possessing arms. Instead, it means the question is to whether the government has the power to disable the exercise of the right they otherwise possess, rather than whether they possess the right at all.
So basically saying they can disable the right, but they cannot
just blanket say, hey, you guys can't.
Yeah.
Importantly,
I don't know if I agree with that, but I think they have the right to bear arms myself, but whatever.
Importantly, the Second Amendment's plain text does not have an age limit, asserting in the plain text 25-year-old age required to serve in the House of Representatives and 30-year-old age required to serve in the Senate, asserting the plain text a 35-year-old age requirement to serve as president. In other words, the founders considered age and knew how to set age requirements, but placed such restrictions on rights, including those protected by the Second Amendment.
Basically, they're saying, well, it's not like the government decide, back then they had age limits, but they just didn't talk about it. Yeah, and there's tons of an example, like age for president, age for to serve in the Senate, and stuff like that, laid out in the Constitution. And if the founders really wanted to put an age limit other than the the 18, they would have stated that in the Second Amendment. Since they did not, the only conclusion we can draw is they were okay with it.
So where are we? Is it ordinary law-abiding 18 to 20-year-old Minnesotans are unambiguously members of the people because the plain text of the Second Amendment covers the plaintiffs and their conduct. It is presumptively constitutionally protected and requires Minnesota to proffer an adequate historical analog consistent with the nation's historical tradition of firearm regulation. Bruin.
Okay, so once it's covered that the plain text, what the plain text says, then it moves on to the second step, which is analogs and a historical analysis, basically.
The historical analysis presumes that individuals' conduct is protected and requires Minnesota to identify well-established and representative historical analog, whether modern and historical regulations impose a comparable burden on the right of armed self-defense, and whether that burden is comparably justified, or central considerations when engaging in analogical inquiry, the how and why respective must be analogous. A threshold As a threshold matter, the district court addressed which time period is better for understanding the scope of the Second Amendment and applies to the states.
Yeah,
Bruin cautions.
basically 1791 or 1868, which is the ratification date of the 14th Amendment. As I stated earlier on in the stream, the states that want to enact gun laws always push for 1868 because there was a bunch of Jim Crow era racist gun laws during the Reconstruction period after the Civil War.
Bruin cautions that not all history is created equal. Rather, constitutional rights are enshrined with the scope they were understood to have when the people adopted them.
I also want to state that the 14th Amendment didn't change anything. It just affirmed that the constitutional rights also put a restriction on state governments as well as the federal government. So it didn't actually change the rights. It just said we're just affirming that the states cannot violate people's rights still.
Let's see, Bruin, quoting Heller, strictly speaking, Minnesota is bound to respect the right to keep and bear arms because of the 14th Amendment, not the Second. Even so, Bruin strongly suggests that we should prioritize founding era history. Otherwise, the individual rights enumerated in the Bill of Rights, made applicable against the states through the 14th Amendment, might not have the same scope as the federal government. And for decades, the court has generally assumed that the public understanding of the right when the Bill of Rights was adopted in 1791. What the Second Amendment is not a regulatory straitjacket, and Minnesota does not need to provide this court with a dead ringer. A regulation that remotely resembles the carry ban will not suffice. A court must ascertain whether the new law is relevantly similar to laws that our tradition is understood to permit. Minnesota must prove that it is consistent with the nation's historical tradition of firearm regulation, the state to ban on account of their age the public carrying of handguns by ordinary law-abiding citizens. For each proffered an analog, this court considers the how, comparable burden, and the why, comparably justified. Why and how the regulation burdens the right are central to this inquiry. And let's see, citation omitted. The how of the carry ban and the burden to be compared is a ban on the bearing of firearms in otherwise constitutional manner. Let's see.
So basically, it's saying the same ban. Okay,
Minnesota states the why of the carry ban is that 18 to 20-year-olds are not competent to make responsible decisions with guns and pose a risk of dangerousness to themselves and to others as a result. Minnesota proffers 3 reasons that the carry ban survives Bruin's historical tradition test: a freestanding catch-all for groups the state deems dangerous, founding era common laws, analogs, and Reconstruction era analogs. Minnesota contends that status-based restrictions from founding era created a freestanding dangerous catch-all analog. If the state deems a group of people to pose a risk of danger, it may ban a group's gun ownership. See Joseph Blockler, Katie Carberry, Historical Gun Laws Targeting Dangerous Groups and Outsiders.
Yeah,
In
basically that included Catholics, Native
shit.
Americans, and Black people. So
Well, okay then.
they are no, seriously. That's what they're talking about.
It's like racist much? It's like, I'm going to support my opinion of law by racism. New Histories of Gun Rights and Regulations essays on the place of guns in American law and society. Joseph Blocher,
Yeah,
Jacob Charles, and Darrell Millers. One can accept that the framers denied firearms to groups of people they thought were particularly dangerous or unvirtuous or irresponsible without sharing their conclusion about which groups qualify as such. Assuming that historical regulation of firearm possession can be viewed as an effort to address a risk of dangerousness, this risk does not justify the carry ban. Minnesota claims that 18 to 20-year-olds present a danger to the public, but it has failed to support its claim with enough evidence.
all right, we
Up,
can skip this. Basically, they're saying that you're saying that they're dangerous, but when we ask you why, you're just like, they're dangerous. Everyone knows
I,
they're dangerous.
that would be easy to have data to show.
They did show that you know that the murder rate is higher, but that's what they use.
I'm sure with illegal firearm possession, yes.
Yeah, so keep on going.
Even if we have no reason to doubt the accuracy of these statistics, they do not support the carry ban. Nothing that the statute at issue did not broadly restrict firearms use by the public generally. For one thing, the Minnesota legislature could not have relied on them. The expert report, which was prepared solely for this case, uses data from 2015 through 2019, more than 10 years after it acted the carry ban. And the record is devoid of statistics that Minnesota could have used to justify a conclusion that 18 to 20-year-olds present an unacceptable risk of danger if armed. After all, even if using these recent statistics, it would be a stretch to say that 18-year-old possessors possess a clear threat of physical violence to another.
Yeah, basically, the state commissioned a study specifically for this court, and the judges are saying that doesn't work because there's no way that they could have used that to pass this law because you did it specifically for this court, and this law was passed before this court case.
For another, Minnesota has not attempted to explain why its other statutory restrictions, none of which the plaintiffs have challenged, do not reduce the risk of danger already. First, permit applications must be complete, training in the safe use of a pistol, and not be listed on the criminal gang investigative data system. Certain state and federal statutes might already render an applicant ineligible, including those who have been convicted of a crime of violence or recent controlled substance offense. What the record lacks, in other words, is any support for the claim that 18 to 20-year-olds who are otherwise eligible for a public carry permit pose a credible threat to the physical safety of others, that their Second Amendment right may be burdened, a legislature's ability to deem a category of people dangerous based on a belief it would subjugate the right to bear arms in public for self-defense to a second-class right subject to an entirely different body of rules than the Bill of Rights guarantees. Let's
Yeah.
see. We conclude only this: an individual found by a court to possess a credible threat to the physical safety of another may be temporarily disarmed consistent with the Second Amendment. While our tradition of firearms regulation allows the government to disarm individuals who present a credible threat to the physical safety of others, Minnesota has failed to show that 18 to 20-year-olds possess such a threat. Accordingly, absent more, the carry ban cannot be justified on a dangerousness rationale.
Yeah. So, basically, it goes over like Minnesota, all the examples that Minnesota lists, and the court basically rejects all this. and they said that the Minnesota did not, present anything credible from the founding era. Then Minnesota tries to argue from the Reconstruction era, which is not the right time period, and basically it states that it's not the right time period. Come on, guys. So with that, so let's just go read the final one here, the final line.
Minnesota has not met its burden to proffer sufficient evidence to rebut the presumption that 18 to 20-year-olds seeking to carry handguns in public for self-defense are protected by the right to keep and bear arms. The carry ban violates Second Amendment as applied to Minnesota through the 14th Amendment and thus is constitutional. This judgment is affirmed.
Unconstitutional, not constitutional,
Sorry.
unconstitutional.
So
So that was a 3-judge panel. The next step is Minnesota is probably going to ask for an en banc from the 8th. And no matter how that turns out, basically, if they are granted an en banc, because the 8th does not have to grant an en banc, they can deny it. En banc just means the full bench will hear it. And let's say if they don't grant an en banc, then Minnesota's option is to file for a writ of certiorari, basically petition the Supreme Court to hear the case. Or if they are granted an en banc, this decision will be vacated, which basically just to reaffirm the district court's decision. Now, when it goes to en banc, all 16 judges will hear it. And there is a couple different things that the 8th can do. It can reverse the decision of the district court judge at that point by a majority ruling. It can affirm the panel decision, or it could be a tie. Now, let's say it's a tie. Let's say it's an 8-8 tie. What that would mean is the district court's decision stands. Basically, in the GOA case on bump stocks, the Sixth Circuit was an 8-8 tie, so the district court decision stand, which said that the bump stock rule was constitutional. That has now been overturned by the Cargill case. So in this case, if there is a tie, the district court judge, which is good decision, which is good for our side, will stand. So that's a good thing. No matter who wins at the circuit court level, both sides are whoever loses is going to file, going to petition the Supreme Court for a writ of certiorari. Or writ of cert just means that the Supreme Court can take it. Now, the Supreme Court doesn't have to take it, but they can. So, yeah, 12 members, whatever. So we'll have to see what happens here, but this is good. Safety Harbor Firearms wants to know, uh, could this decision have effect on Florida's 18 to 20-year-old ban? Yes, it could, but not directly. So this decision does not knock down the Florida law, but if anybody challenges the Florida law, what they can do is file a brief of supplemental authority, which references the Eighth Circuit's opinion on that. And that brief of supplemental authority does weigh heavily on the courts because the courts don't really like to fight with each other. So that brief of supplemental authority could help knock down the Florida law, but it's not guaranteed. This does not have a direct effect on it, but it does have a effect on it from the writ of supplemental authority. And the people challenging the 18 to 20-year-old ban in Florida, I can guarantee you that they're going to file a writ of supplemental, not the writ of supplemental authority, a brief of supplemental authority because of this. I can guarantee you that. So, yeah. So there you go. I hope that made sense to you.
So at this point, like if you're 18 to 20 in Minnesota, you can get a carry permit.
Oh, why aren't they doing this in places like New York when we get a good ruling from the 5th? They are. if you look at every New York case, for example, Antioch, all the Fifth Circuit's decisions, there's been briefs of supplemental authority. Just because they do a brief of supplemental authority does not mean that the third, fourth, fifth, or sixth, or whatever court system, the other circuit courts have to take it. They do have to take it into consideration, but they do not have to abide by that. Yeah, but there's been tons of briefs of supplemental authorities filed, and not only the New York cases, but in California cases, a bunch of different cases.
So I actually got my first carry permit in Minnesota, but I was residing temporarily in Hennepin County. And because I was a non-resident, if I went to Hennepin County, the sheriff there slow walks and tends to deny, whereas I could go to any county in the state and go to another sheriff that basically hands out permits and sets them at a lower price. So Minnesota is kind of an interesting state that way.
Yeah. Pennsylvania's kind of similar too, but now he can't deny it because the whole entire.
Yeah, whereas Florida, you get your permit from the state government as opposed to the county sheriff.
Yeah, by Florida is interesting because the agriculture department
Department of Agriculture.
that who issues you the permit.
And that's why Nikki Haley ran and won the Department of Agriculture, because she was a lefty lackey.
And Nikki
But
Haley,
she's no longer in office. Not Nikki Haley. I'm sorry, Nikki
Freed.
What was it? Freed? Yeah.
Nikki Freed. Man, I'm not
Another Nikki.
and I know who runs the Department of Agriculture. She's a pothead. But yeah, that is basically it. If there's no other questions, we're gonna wrap up here. But this is a good decision here. Yeah. So basically, he said if that was the case, then Walter has a great point here. If it's inherently dangerous, no 18 to 20-year-olds should
Or drive cars.
Exactly. Yeah. All right, guys. That is it. I hope you guys have a great day and stay safe, stay kind. And do we have a guest for today?
Yeah.
5 o'clock. Is it who I think it is?
Rick Vasquez.
Rick Vasquez, who used to run
Fat D.
The firearms technology branch of the ATF. He used to be the head of the ATF, Fat D, and he will be on the show today talking about some stuff that he wants to talk about, and that's over on John Crump Live, which should be pretty cool. All right, guys. So I will see you guys later, and with that, we are out of here. Love you. Bye.